And now, welcome, distinguished ladies and gentlemen. Good afternoon from Nigeria. It is my pleasure on behalf of the Nigerian chapter of the Internet Society and the Dear Governments Organization, or DearGovs for short, to welcome you to the pre-release webinar of the project report on the Internet Impact Assessment of Nigeria's proposed social media bill. I am Emmanuel, founder and president at the Dear Governments Organization, and I would be your host at this virtual event. You can find me on Twitter and LinkedIn at the handle showing on the screen. As a preamble to commencement, and to establish why we're gathered here at this time, I wish to make you aware that since December 2020, the Internet Society, in collaboration with the Dear Governments Organization, have collaborated, have partnered on a multi-phase project that aims to assess the impact on the global internet of certain internet-related government regulations drawn from various countries around the world. This project is the product of a synchronization between the Regulatory Observatory Division at the Dear Governments Organization and ISOC's the Internet Way of Networking Project, or I-1 for short, which was part of ISOC's action plan for the year 2020. The first tranche of this project, which has now been completed, has been focused on Nigeria's proposed social media bill, which was passed, or which was drafted and proposed in 2019. This collaboration that has given birth to this event, which is being co-hosted by the Dear Governments Organization and ISOC-Nigeria chapter, is pleased to have your presence here at the first public webinar of these projects. And then we are co-hosting this event to bring together internet stakeholders from across the Nigerian internet ecosystem to deliberate on the implications of this bill and the recommendations of this report as we have emerged with in the first tranche of this project. And furthermore, we hope that as a deliverable of this virtual event, a policy brief would emerge to capture the crux of our deliberations and recommendations at this event, and also the inputs and thoughts of leaders who represent various stakeholder groups across the major communities of the internet ecosystem, the technical, regulatory, the civil society, and the academic or research community. We would collate these ideas and emerge with a policy brief that is intended to serve as an advocacy tool for progressive engagements with lawmakers and legislators, as well as other stakeholders, on the crucial matters that emanate from this proposed bill, and also to drive the necessary changes and transformations that are needed to make this bill more applicable or more progressive in light of the visions for a sustainable growth and development of the internet. And so that is why we are here today, to bring life and substance into our deliberations and discussions here today. We are privileged to have the presence of a distinguished lineup of 5 high-profile panelists who would be formally introduced to you at the right time. But for now, I would like to invite the chief co-host of this virtual event, in the person of Mr. Caleb Olumuyiwa Ogundele, the president of the Internet Society Nigerian chapter, to give the formal welcome remarks. Caleb, you have the floor.
Thank you very much, Emmanuel, and it's good and exciting to see that we are collaborating on this project together. One of the interesting things that is happening right now to the entire world that has helped us, especially in this COVID space, is to see the importance of the social media plays in our everyday life in communicating with friends, family, and it is also a good thing to know that we are engaging and speaking about these things, specifically in the Nigerian space. Fortunately for me, I happen to be in a space where social media is being gagged right now. And for me to be able to access the social media, I will have to use a VPN connection to connect. So it makes it quite difficult to actually access the social media at this point in time. And I'm excited that my own country is speaking about this, and folks around the world are also speaking about this. So on this note, I'd like to welcome everyone to this webinar, and I would also like to welcome all our panelists, and thank you for accepting the invitation to be part of this webinar. So on that note, I'd like to yield the floor to the moderator. Emmanuel, you can take over. Thank you very much.
Thank you, Caleb. And like I had mentioned earlier, and Caleb has just confirmed, this event, this webinar is a product of this collaboration between ISOC and her Nigerian chapter and the Dear Governments organization. But then I would like to assume that to all who are gathered here today, the Internet Society needs no introduction, not even the Nigerian chapter, because indeed the pedigree of the organization precedes the name. As a reputable global organization that has championed the gospel of multi-stakeholder internet governance for almost 3 decades. However, I would like to invite Veronica, Piccolo, my colleague, co-founder and vice president for research at the Dear Governments organization, who will tell us a little bit more about the organization, which is the Dear Governments organization, and the work that we do. Veronica, you would have the floor now.
Hello, everyone. I hope you can hear me fine. Can you hear me? Okay, thank you. Welcome, everyone. Thank you, everyone, for taking the time to attend. This is Veronica. I'm currently based in Italy, and please allow me to thank Emmanuel, who is leading this project and has planned this webinar, but also thanks to ISOC-Nigeria for co-organizing and hosting this event. And most of all, and heartfelt thanks to all the distinguished panelists who accepted to be here and give their contribution. You must know that this is very important for us. I will quickly outline who we are, what we do, and how. We describe ourselves as a youth-led intervention advocating for an open, trusted, and non-manipulable internet. We are a civil society stakeholder group in internet governance, and non-governmental, non-profits, and DearGovs is coordinated and run entirely by young volunteers from around the world. Our team, I like to think that our team is a remarkable example of cooperation across multicultural, multiracial, and multi-regional leadership being our membership based in Europe. So I come from Italy, and in Africa, so in Morocco, in Nigeria, in South America, in Haiti, and North America, in the United States. Our main interlocutors are governments especially governments that undertake improper regulatory initiatives pertaining to the internet, especially when they jeopardize the integrity of the internet itself. We work to inspire governments to act more responsibly in the execution of their mandates. What we do is to amplify and push the boundaries of the multi-stakeholder model, trying to foster the participation of young people and to promote and bring the multi-stakeholder policy-making process within national parliaments, especially when it comes to internet public policy. Because, you know, the internet is a complex ecosystem. It's a complex technology. And most of the time, initiatives like the one that's going to be discussed today threaten the sustainable growth and development of the internet. And sometimes governments don't even realize it. So here we are to make a stand. And how do we do it? We do it in 2 steps. The first step is research. We have a regulatory observatory. We detect potential problematic policies, laws, bills, but also case laws, for example. We undertake evidence-based research projects in partnership with other stakeholder groups or internet governance ecosystem. And then we move to the second step, that's open advocacy. We want to raise awareness about the pitfalls of those public policies. And in order to get the message across, we trust in bottom-up approach, inviting all the stakeholders to have a say about it. Okay, this is, I was saying that this is a multi-stakeholder discussion. We like to have this multi-stakeholder discussion in a very transparent way. We trust in transparent processes. So now regarding the proposed social media bill, we are between phase 1 and phase 2. We have finalized the analysis and now we're seeking the contribution from the other stakeholders. And I'd like, of course, to invite you to reach out to us, and especially young people want to have their first approach with public policy to reach out to us. And this is all from my side, and I leave the floor to the other panelists, and I'm here to listen to this amazing conversation. Thank you.
Thank you, Veronica, for that very apt and straight to the point introduction. You see, the project that gave birth to the webinar we have gathered here to be part of today was made possible by an action plan of the Internet Society, the Internet Way of Networking Action Plan. And this action plan has been conceptualized to help to engage with the various activities of Internet stakeholders that tend to create an imbalance in the playing field of the multi-stakeholder Internet environment, wherein some stakeholders try to exert a higher form of control, either by way of regulation or other business-oriented means, against other stakeholders who have little or who should have equal participation, so to speak, in the Internet space. And you know, the Internet Impact Assessment Toolkit was developed by the Internet Society to help make initiatives like this possible, wherein this toolkit helps to assess and study regulations of various governments across the world, and then gauge the extent to which they impact on the Internet way of networking. Among us today is a senior policy advisor for the Internet Society in person of Mr. Verengai Mabika. He would be taking the floor at this time to
see whether the thing has finished now.
Verengai will be taking the floor at this time to help shed more light on the Internet Way of Networking project, and more specifically, the Internet Impact Assessment Toolkit. Verengai, you have the floor now.
Thank you very much, Emmanuel, and greetings, colleagues from Nigeria and around the world. I've seen some colleagues who are joining from Canada, the US, and I'm actually joining from Zimbabwe. So it's a pleasure to join you in this discussion to discuss an interesting development in Nigeria, but also the assessment that the two organizations have made in attempting to at least understand the dynamics of this proposal. So I first like to thank the organizers of this webinar, DearGov and Internet Society Nigeria chapter, for giving us an opportunity to share the Internet Impact Assessment Toolkit, which we believe could be one of an important tools that can be used for purposes of, reviewing legislation or government policy related to the internet. Allow me to share my screen. Please confirm if you can see my screen. So
yes, we can see your screen.
Great, thanks. So once again, my name is Verengai Mabika. I'm from Zimbabwe and working with the Internet Society as a senior policy advisor for Africa. And the purpose of this discussion, I think, being given an opportunity to be the first speaker, the idea of the Internet Impact Assessment Toolkit that we developed, in fact, it was launched last year, 2020. And we are quite excited that Nigeria is among the first countries to make use of this toolkit. Our thinking is actually to have this tool as an environmental impact assessment for the internet. So similar to what we do with environmental projects across the board. I think you might be aware that, in many instances, when a big development is happening, it could be a mining project. There's an attempt to understand the dynamics or the negative or the positive impact of such a development. So the impact, this toolkit is actually meant to do more or less the same thing for the internet. Why we thought of this thing is generally because what we are seeing, what we are observing and seeing around the world is that governments and businesses are increasingly making decisions that we think could impact the internet either positively or negatively. And in most of these cases, they might not even know that, the developments they are making could have an impact on the internet. I think, colleagues, you might have followed some discussions that happened, I think, late last year with businesses like WhatsApp, for example. I think they were making some changes on their privacy policy, and there was a big uproar, I think, across continents on, especially the continent of Africa, why WhatsApp wanted to share some information with Facebook, its parent company. So those are the kind of developments that we're talking about here. Developments that could have an opportunity, an impact on the way we look at the internet today. And this is just one example of such developments. In Africa, I think we have so many developments that happens on a day-to-day, having one of the biggest continents. And particularly, I think this event is going to be looking at the proposed social media bill for Nigeria. But there are many other interesting things that happens in the continent. For example, in the past, there's been talk about countries having an interest to impose digital taxation in countries like Zimbabwe, my country, Uganda, South Africa. There are also other developments that happens, especially when there are major events, internet shutdowns. I think we have seen governments making a very strong positions on a national development, like in an election. Recently, I think it happened in Uganda, where the internet was shut down because they suspected that it could be abused for purposes of getting candidates to win the election. But what we have seen with the project that Emmanuel mentioned, the Internet Way of Networking, or I1 project, which is one of the projects that we are focusing on for the next 5 years, we are beginning to know that the internet has been very resilient, especially in light of the pandemic that we all know of. COVID-19 is still with us, and we have seen that most of our work has moved to virtual spaces. It may be schooling, it may be socializing, collaborating, and education industry, banking, everything almost moved to internet spaces. So what this tells us is that whilst many of the governments were not prepared for this coronavirus, the internet was actually prepared for it. So it shows, and the reason why the internet was prepared for this is because of the critical properties that underpin the strength and the success of the internet. And this is where the Internet Impact Assessment Toolkit is hinged on. In fact, this is the backbone of the toolkit. So with this toolkit, what we attempt to do is really to define the 5 critical properties of the internet way of networking. These critical properties, we believe, are the ideals that makes the internet thrive, or that makes the internet resilient and continue to grow, continue to to be dynamic, to be resilient in very different occasions. And let me attempt to quickly look at these critical properties, just to briefly discuss some of them. I know I've got about 10 minutes, so I'll try to rush through, and maybe we can come back to questions when there is need. So the first critical property, an accessible infrastructure with a common protocol. I think this is a very important critical property of the internet that we have seen over the years, that the only thing that you actually need, the only technical requirement for you to be on the internet is actually the IP, the internet protocol. I know Nigeria is trying to promote the adoption of IPv6, for example, which is a much broader protocol that can accommodate maybe more people, more things online. So the internet protocol it's unrestricted access, and common protocol makes it very easy for individuals to connect and encourage the network to grow over time. So as more and more participants do connect, the internet becomes a very important network of networks for many different individuals around the world. Then the second property, again, that we try to present in this toolkit is a layered architecture of interoperable, reusable building blocks. I think one of the fundamental properties of the internet is that its development process, its standards have been developed very openly. Some of you may know the Internet Engineering Task Force, the organizations that deals with the development of internet standards, which is a very voluntary organization, and the adoption of these standards is also voluntary. So there is no attempt to force people to take a particular direction. It is only measured by the demand that is created by these standards. So I think this is again a very important aspect or a critical property of the internet that we have to make sure that we don't tamper with. Otherwise, we might lose the value that comes with the internet. Then the third critical property is the decentralized management and distributed routing system of the internet. I think this again is a very important aspect that to date, there are possibly close to almost 70,000 networks or autonomous systems that runs on a common open routing protocol. But all these are able to interoperate and connect very easily. There is no centralization or a central authority that makes the internet work, but a distributed and very decentralized nature of the internet makes it very resilient. So there are many, networks, autonomous systems gathered, networks of networks across the world. And this is an important element of the internet that we think we have to preserve again. And any attempt to build a new, or I mean to create a new policy or legislation, again, should make sure that it attempts not to disturb this particular property. And then the fourth one is a common global identifier system. I think, again, this is a very important element. We believe that this allows for purposes of creating spaces that suit the needs of specific applications. And it also helps with predictability and universality of the internet as a system itself. So again, this is another, the fourth critical property that we believe. And then lastly, a general purpose network. So if you look at the history of the internet, you can see for the fact that the internet was really designed as a general purpose network. It's not optimized for a particular use case that you can say, you know, a voice or a particular pattern that you can describe. Anyone or any day you can come on the internet with your own, you know, innovation. It could be TikTok. I think TikTok has become very, very popular with the young people in the last 2 years, especially during the COVID-19. And we never expected that TikTok could, sort of get that kind of popularity in a very short space of time. We are using Zoom right now, and Zoom again, it's riding on the internet. So the internet, the backbone of the internet is really a general purpose network. It doesn't matter what you need. Anyone is allowed to come without seeking permission from anyone. And definitely, I think this is another important aspect that makes the internet what it is today. So having looked at these 5 critical properties of the internet, what we did develop is what we now call the Internet Impact Assessment Toolkit, which is really hinged on these fundamental critical properties. And what this toolkit really does is that it helps the policymakers, or it could be organizations such as the ones that are leading this discussion, to be able to analyze and explore how certain decisions could, or certain trends could actually impact the internet. So our hope and our belief is that this impact assessment is similar to how we use the environmental impact assessment for environmental projects. It can also be used for reviewing the developments that are happening in the space. What the toolkit actually do, I think I'll also send a link for those that may have an interest to look at it, but I'm sure most of the colleagues might also have had a chance to look at some of the toolkit and some of its contents. So it also provides some use cases on internet threads. So it looks at particular use cases. Let's say you may want to advise the government on how they should handle social media or privacy, or maybe it could be internet shutdowns. There are certain use cases where we try to analyze what has happened in other countries and how they've tried to look at a particular development. It have some kind of infographics and some questionnaires, frequently asked questions when it comes to a particular trend or a development that happens on the internet. So in essence, what we are thinking with this toolkit is that it can help either governments, policymakers, technologists to be able to make the smart decisions. We are not saying that regulation is bad. We know that in many jurisdictions, in many countries, there is an interest to regulate certain aspects of the internet, but we are just cognizant of the fact that when that regulation is about to come, or when that policy is about to come, let's take a step back, look at the critical properties of the internet to see if there's any chance of harming some of them, because we might lose all the benefits that we have seen, especially now that everyone has seen how important the internet is, especially in light of the pandemic that we had from last year, and it's still with us. So I would encourage you, colleagues, to have an interest in this toolkit, which provides some good, interesting, and dynamics on how to review certain internet-related policies. We have just launched a new course, an e-learning course again, on understanding the dynamics of the internet way of networking. So again, I'll share some links in the chat for those that may have an interest. So I think with this, I'll say, let me stop here and, sorry, let me just stop share and back to you, Emmanuel. Thank you, colleagues.
Thank you, Verengai, for that very detailed introduction to the Internet Impact Assessment Toolkit and what it is, the purposes that it was designed to serve in the internet ecosystem. And thanks to ISOC for designing this wonderful toolkit. We have had an exciting time using this toolkit on this project that I will be talking about in a few minutes. And I encourage everyone to get enlisted for the course, which will be posted in this slide, and get to enjoy working with this toolkit as you engage with various government regulations and other practices within your jurisdictions. And quickly, I'm going to give a brief overview of this project report, which you can access at the link showing on the screen. Basically, the link would give you a more a broader perspective into the report and its recommendations and its findings. But I would give a very brief rundown of the major points that emerged from that report. So on October the 5th, 2019, a bill that has been widely nicknamed as the Anti-Social Media Bill, even though it was originally titled Protection from Internet Falsehood and Manipulations Act 2019. This bill was introduced to the Nigerian Senate by an honorable senator representing the Niger East constituency of Northern Nigeria. But after the bill passed the first reading, it was made public for hearing, and then it was met with a lot of public outcry. The hashtag Say No to Social Media Bill might be familiar to some of you in the Nigerian social media space, as this became a rallying point for public outcry and the campaign voices against the bill. The Human Rights Watch has described this bill as a disturbing trend towards repression of freedom of expression in Nigeria that would have made the death penalty a possible punishment for hate speech. And in the same vein, we have seen Amnesty International also describe this bill in similar terms by saying that the bill represents an alarming escalation in the authorities, that the Nigerian government's attempts to censure and punish social media users for freely expressing their opinions, and also further giving authorities arbitrary powers to shut down the internet and limit access to social media, and make criticizing the government punishable with life imprisonment and the death penalty. Now, this is very interesting if you consider when you consider this in light of the reputation of the human rights reputation of the Nigerian government in the recent past. It's also interesting to note that there is on record an unsuccessful attempt at enacting a similar legislation in 2015 as a bill that was titled the Free Petitions Bill. Following much public outcry as well, similar public outcry and international condemnation at the time, this bill could not pass. But then we have seen, or experts have who have analyzed that bill and analyze the current Cybercrime Act of the year that was passed in the year 2015, suggests that much of the provisions that were protested against in that bill have now been couched under the Cybercrime Act of 2015. But then in summary, the social media bill was intended to prevent the transmission of false information in Nigeria, whether it is perpetrated by an individual person or some corporate entity, and also make it possible to take counter actions to tackle the consequences of such transmissions. Also, the bill also aimed to destabilize acts that help to fund and promote locations, which could be various places on the internet, user accounts, websites, internet sources, media organizations that frequently transmit false information in Nigeria, while also establishing methods to caution and seek redress against bad behavior that is propagated by such online locations as well. Now, what is also interesting to note is that the bill also sought to improve disclosure information around sponsorships for such locations, and then more specifically prohibit transmissions of information on the internet that relate to Nigeria as long as information is believed to be false, regulate the actions of internet intermediaries, service providers, and the likes. However, we have seen that specific regulatory provisions of this proposed bill might be harmful to the internet way of networking, which Mr. Verengai has just described or discussed some minutes ago. And so on the screen, I have put side by side two aspects or two portions of this bill. The first one, which you have to the left, is describing an intention of the bill to ban an online location for repeatedly contravening instructions or repeatedly violating directives not to post false content, and also make it impossible to access these locations directly from any location in Nigeria, as well as other locations that tend to share or mirror the information that you find on this at this location. So for a period of up to 2 years, this part of the bill, Part 5, Section 27, subsections 3, 4, and 5, enable a government agency to make it impossible for you to contact or be able to reach a certain online location that is believed to be perpetrating or publishing false information about the Nigerian government or about Nigeria. And also other locations that share or mirror this information as well are also going to be affected by this part of the regulation. And then the second part of which you see on your right, Part 4, Section 17 and 18 of the regulation talks about two specific items of regulation or two specific provisions. The targeted correction regulation, which is aimed at an internet intermediary that would translate or transmit an information declaring that a particular online location has been flagged for repeatedly posting false information or false statements of fact. And there is also the disabling regulation, which aims to also penalize internet intermediaries by disabling their access or disabling access to these, or disabling the license of these internet intermediaries for failing to take action against these online locations. So that part is a double-edged sword. So it mandates internet intermediaries to take action against online locations that post false information, and then it also enables these internet intermediaries to be penalized for failing to do that. And so there is the implication of this to the internet way of networking, which Verengai has described. Critical property number 4 of this internet way of networking or impact assessment toolkit relates to the fact that the internet is made possible by certain common global identifiers and protocol systems that power the operations of the internet. We have the transmission control protocol on the one hand, we have the domain name system on the other hand, we have the internet or the IP address, as part of the basket of global identifiers that help to make communication on the internet possible. But then implementing these provisions, which we have seen in the preceding slide, would mean that users who intend to visit an online location that has been declared, in the words of the regulation, as having flouted directives against posting false content. So users who intend to visit this location are likely to end up at a destination other than that location which they intended to visit, simply by virtue of being Nigerian, nothing else. And also because the unique identifier to that intended location would have been tampered with, ostensibly. And also critical property number 2 that relates to the open architecture of interoperable and reusable building blocks also helps us to understand that to post a notice online that would be ostensibly visible to Nigerian end users alone would require that some form of filtering or content filtering is done to categorize viewers who are allowed or disallowed. Now, the idea is that we want to, or the government, by virtue of this regulation, want to make sure that users in Nigeria or users connecting from Nigeria are unable to view information that is believed to be false about Nigeria. And also information that is transmitted by vendors outside, which is believed to be false about Nigeria, are not visible to users in Nigeria. For this to happen, we need to be able to filter. There would be the need to filter our users and categorize them among those who are allowed and those who are disallowed. And for this to happen, some form of blocking will be possible. Now, this leads us to the problem of over-blocking, which posits that when we intend to block certain online locations, in the way the internet is structured, the subnetting and the subdomain arrangement of the internet, we are likely to end up blocking more than we intended to block in the first place. And these actions also have implications for the performance and security functions of the internet's domain name system. So this is the first part of the analysis. And then the second part of the analysis relates to 2 other pieces of regulation, which you see on the screen. The first part relates, which is part 5, section 28, subsections 2, 3, and 4, relates to the access blocking order, which is an order to block access to an online location from within Nigeria that will be issued by the NCC, the Nigerian Communications Commission, which is the umbrella regulatory body for internet service providers and intermediaries in Nigeria. So this part of the regulation would ensure that online locations that are declared as false can be blocked for repeatedly violating certain regulations of a certain part of the bill that prohibits or regulates the actions of that internet intermediary. Now, on the right-hand side, where we have part 4, section 23 shown, this part relates to an access locking order. Now, it functions similarly to the access blocking order, except that in the case of an access blocking order, we are targeting declared online locations. But in the case of an access locking order, it is targeting internet intermediaries who fail to take reasonable steps to disable access for end users in Nigeria to online locations that have been imposed with an access blocking order. So one is interposing or superimposing on the other. The access blocking order is superimposing on the internet intermediary to enforce actions that relate to the access blocking order in part 5, section 28. And here are the implications that we have found out. With respect to critical property 4, which relates to the common global identifiers, there is also the possibility that implications could extend to critical property 3, which relates to the decentralized management and the single distributed routing system of the internet. In other words, to effectively block or lock access in the manner that this regulation specifies, we are going to need to implement some form of content filtering, similar to that which we discussed in the previous analysis 1. And in this case, we are trying to, the goal would be to isolate or segregate packets or traffic that are originating from a particular destination or a location rather, or source of destination, which is Nigeria in this case. And then what happens to that traffic next would determine the impact on critical property 3. So when packets that are originating, when packets are trapped on the internet, so to speak, originate or transmitting from one location to another, when packets are trapped, one of 2 things would happen. It is either they are dropped summarily or they are rerouted to another destination. Now, In practice, when Nigerian-owned or Nigerian-based online locations are blocked internally within Nigeria, external locations or international traffic seeking access to these locations as well would also be affected by the implementation of these rules or by the implementation of this provision of the regulation. And so we begin to see that in practice, several aspects of this regulation coalesce to create a problem that altogether compromise the global reach of the internet. Not only because, in this case, connectivity and routing decisions between networks and their nearest neighbors, which powers the principles of information exchange on the internet, routing would no longer be resilient, optimized, and driven by local interests like pricing, available resources, connection bandwidth, reliability, and the other characteristics that help to ensure the routing is optimal and is resilient. These will no longer be the considerations, as now it will be difficult to reach a particular online location, even when you have the correct global identifier that links or that maps to that particular online location. Now, beyond these, and to wrap up, there are emerging governance issues. The first relates to who decides what is false on the internet. Now, in the words of this regulation, there is no part of regulation where that falsehood is described. And so this creates an ambiguity with regards to how do we describe what is false. Now, the other part relates to who is responsible for enforcing internet-related regulations. In this regulation, the Nigerian police force is ostensibly positioned as the single agency that will be responsible for interpreting, enforcing, and also dealing with issues that relate to this bill. Now, this raises questions of how, this has raised questions, existing questions by experts of how competently the Nigerian police force is trained to deal with the technical realities of these enforcements. And also there is the technical intricacies of how this will be enforced, these regulations, the regulatory provisions will be enforced, which raise questions of whether the technical community was actually carried out, and shouldn't these technical intricacies have been factored in as part of the development of this regulation. I would yield the floor to Bukola Oronti at this time, who would introduce the eminent panelists that will be engaging on these questions and other questions that will be emerging from other participants in the course of this webinar, who would be giving us more light and more insights and more thoughts on these questions in the next few minutes. But Bukola Oronti would do the justice of introducing these panelists at this time. Bukola, you have the floor.
Okay, thank you very much, Emmanuel. I hope you can all hear me.
Yes, we can hear you.
Okay, thank you very much. So I welcome everyone once again to this meeting. And permit me to once again introduce to everyone, Emmanuel Ogu is the president, founder of DearGovs. And of course, he will also be moderating this panel discussion session. So I also want to welcome the following panelists to this discussion. The first person I have here is Oluwatosin Abolaji. He's a digital inclusion program manager with Paradigm Initiative. And the second on my list is Abdul-Hakeem Ajijola. Is the chair of Nigerian National Cybersecurity Policy and Strategy Committee. Also, I'll be welcoming Verengai Mabika, the senior policy advisor with Internet Society. And also on the panel is Mojirayo Ogunlana-Nkanga. She's a legal practitioner and digital media, gender and human rights advocate. And finally on the list is Ridwan Oloyede. Is the co-founder of Hive Advisory. So once again, I welcome all our panelists to this call and permit me to leave the floor for Emmanuel Ogu. Emmanuel, over to you. Thank you.
Thank you, Bukola, for that very straight to the point and apt introduction of our panelists. So I would begin with the first thought question by trying to understand from the viewpoint of the panelists, what is the general perception of the proposed social media bill at this time? How I believe you've all had an opportunity to check out this regulation, this piece of law, and you might possibly have some thoughts in addition to that which has been captured in the report to share. So quickly, just give us an overview of your insights in 1 minute or less of what you think is the greatest issues or the greatest concerns or the strong points or positive aspects of the social media bill 2019. I would begin with Ridwan. Ridwan, you have the floor.
Hi everyone. Thank you, Emmanuel, for the invitation. Yeah. So one of the biggest impact and one of the biggest concerns that has been generated from the content of the bill or what the bill is trying to achieve. I mean, while we can say there is a valid concern for some of the things we've seen around how users are using the social media lately, there's a big problem around disinformation. There's a big problem around how the impact of disinformation have real life impact on the daily lives of people. But also taking extreme measures, which is my own personal opinion about what the bill is trying to achieve, to sort of quote unquote regulate this space, would have greater impact on the right of freedom of expression, for example, as expressed under the Constitution, and of course, as we know, under other international human rights norms. So the biggest concern has been the conflict of the content of the bill, the way it's currently phrased, and the potential impact it's going to have on freedom of expression to people. And not just freedom of expression offline, but speaking about freedom of expression online, which of course expresses itself in so many different ways, which we're going to get into pretty much later. So I'd like to just put it summary that way, because I have just 1 minute to say that. Thank you.
Thank you, Ridwan. Moju, would you take the floor next?
Okay, Emmanuel,
Moju, can you hear
let
us?
me
Yes,
do that.
thank you.
Let me take the floor next. Okay, hi everyone. Mojirayo. Okay, so what should I say? From what Emmanuel has just done, putting these two provisions side by side, apart from all that I have and all I can see about the social media bill, I want to say that the government has shown over the years, even after I was part of the civil society organizations that have vehemently and came out strongly against this falsehood, you know what they call it, but we all know it's the social media bill, and that is the perfect coinage for it. And we can see from 2019 till date that these things that you just read out, the technical words, I don't know the technical words, I only know the legal words. They are already taking place, because someone like Fisayo Shoyombo and the People's Gazette have reported that from when you're trying to go into the People's Gazette's website from certain networks, you cannot reach into that the website to read a report, which Nigerians have the right to read. Now, what the social media bill is going to do eventually, if we allow it to be passed into law, is to prevent transparency from the government and to prevent accountability. And I don't need to emphasize so much about it. And a key example is what happened on October 20, 2020, when Nigerians from wherever they were and other people from all over the world were watching a particular event live on Instagram. And then your Nigerian government, through your Minister of Information, comes out and tells you, you didn't see what you saw. And so imagine a law that gives them so much power to restrict us from speaking, restrict us from criticizing, restrict us from putting our government in check. You know that we have a lot of problems in our hands.
Thank you, Moji, for sharing your thoughts. Okay, so I would would also like to hear from Mr. Oluwatosin Abolaji at this time. Mr. Oluwatosin Abolaji, you have the floor at this time. Okay, I hope he can hear us. Hear me, Tosin? Okay, we are going to move to Mr. Ajijola as we await to hear from those connectivity issues. Yes, Mr. Ajijola, will you share your thoughts? You have the floor at this time.
Sorry, I think you will go back to Tosin. I just made him a co-host now. My apologies. That's the reason why he could not unmute himself. But you can go on, Mr. Ajijola, after which Tosin will come up.
All right, thank you.
Yeah. Okay. Tosin, I think you go ahead now while we take Mr. Ajijola next.
All right, thank you so much, Emmanuel. Yes, I was just trying to inform you that I was unable to unmute my mic. Yeah, thanks so much.
Sorry about that.
Yeah, that's fine. Yeah, thanks for the insights that was shared when you were giving the reports, and I think that was very helpful. And looking at from an organization that works with especially young people, and for the fact that we encourage a lot of young people to embrace technology and which a lot of them have seen the social media as one of the platforms that they can express themselves and get a lot of things done. So for the social media view, one of the concerns for us is the fact that there's a whole lot of clauses that does not support creativity, and which is a concern for a lot of young people, and which will definitely have an effect on their confidence. And one of the things we've been able to understand is that a whole lot of this audience that we work with don't even understand what the social media bill is, and that is a concern. It's a concern, the fact that they see the social media as a platform where they can do a lot of things, and as well, not knowing that there's a threat to it. That means that your creativity can always be questioned, and having that, it's a concern for us as an organization, and that angle is really something that we've always pushed back and see how a lot of things can be done around that. Thank you.
Thank you, Tosin, for sharing your thoughts. I totally agree with you that the fact, the point of non-awareness, that people do not understand how these issues affect them on the broad scale. We would have Mr. Ajijola's thoughts at this time. You have the floor, sir. Okay, I hope he can hear us. Is he able to unmute? I saw him in the chat. I saw him in the list some time ago.
Thank you. Now I can unmute myself. So as I was saying, good afternoon. Let's look at the issues of social media control. First of all, there are issues relating to freedom, but specifically freedom as in agency. That is the capacity to act, capacity to make decisions. Social media control is about power. It's about money. It's also about respect. It's also about social interactions and social boundaries. And very importantly, it is about trust. Now, the challenge we face, and this is specifically in Nigeria and Africa, not so much in other climes, is that social media, frankly, is regulated. Anybody who believes social media is not regulated needs to ask President Trump. They got the social media got to a point where they were fed up with him. But the issue is, who controls the social media? As of today, the primary control of the big social media companies is in Southern California, and they primarily respond to their shareholders. The control is by their shareholders, and then what we'd call the North American regulators. Social media is not controlled by us, but it is controlled by somebody. And so we must understand that there needs to be some level of regulation of social media. But that regulation, it is imperative that it is within the context of democracy, but not just democracy on paper, but democratic values. And I think this is where the social media bill and the previous bill fall significantly short. Putting a clause, because you are a member of an elected National Assembly, does not mean you have democratic values. And And so the big challenge I see in part with the social media bill is that it's very reactive. And for most of us know that reactivity is a sign of failure. We need to be proactive. And so what we also need to do, and this is a message that I send out to ISOC and the community as a whole, is that we need to also assist the National Assembly and the legislators with research so that they can actually begin to make informed decisions based on real data, based on real insight, and not just some emotional reactions to one perceived slight or the other. So we need to have some kind of data-driven decision-making mechanism based on real research and development, which I'm very happy to see you are doing. You know, that's how you've come up, for example, with the toolkit and many of these other things. But the critical thing is that Nigerian legislators, African legislators need to be empowered with much more knowledge, because we must also realize that even if you put the bill in place, any of you that are military historians will have heard of something called the Maginot Line in Europe. And like all walls, whether it is the Maginot Line, the Great Wall of China, even the Great Firewall of China, which is the internet firewall, can be bypassed. And indeed, there are VPNs that are free that help you to bypass. And of course, the general citizenship cannot bypass these things. But my point simply being that the bill itself seems to be based on a lot of uninformed, emotional reaction. And I think this is the core of what we have to also try and address. Thank you.
Thank you, Mr. Ajijola. Reactivity is a sign of failure. I think that hits me very impressively. Thank you for sharing with us your thoughts. Mr. Verengai, would you take the floor briefly for the next under 1 minute, if you have thoughts to share in addition to that we already have?
Thank you, and great to hear from you. I think we've connected before on the African Union Cybersecurity Expert Group. Yes. I don't think I would add anything. What is said, really, I think those are important points. I was quite struck by the knowledge that he has. So I think I'll pass.
Thank you, Verengai. So I would ask quickly, I would still stay on Mr. Ajijola. So are there any indications or indicators from the bill that suggest that there were technical considerations? You've already mentioned the fact that the bill seems to be more reactive than proactive. But then, you know, there is the possibility of arguments to come up that, okay, we tried to, I'm talking about on the part of the legislators and the government, we tried to carry on along as much part of the technical community as we can. So from a technical standpoint, are there aspects of this bill that indicate that the technical community may have been carried along at some point, or the technical community was not carried along at any point? What are your thoughts with regards to having featured the thoughts of the technical community in this context?
Very bluntly, I do not see the footprint of the technical community. It is possible that they consulted somebody. One, it wasn't me, and I don't know whom. So even if they did talk to somebody or some technical people, one has to question or ask questions about their technical capabilities. And the reason really is that the bill is not well thought through. It's relatively poorly articulated. And the truth of the matter is that they've not factored that, you know, to build the necessary tools and infrastructure to block internet access en masse are not cheap. And even as an economy, I just don't see how we can really afford it. So I cannot say that they didn't consult the technical community, but certainly they didn't seem to, or they overrode the advice, and that does happen as well, of the technical contributions. There's a lot of legalese there, so clearly there was a lot of consultation with legal people, and this is one of the challenges and this is from experience, particularly in Nigeria, but often when some of these cyber bills are being articulated, they tend to rely much more on the legal input as opposed to the technical input. So I don't see the technical footprint. Thank you.
Well, thank you, Ms. Ajijola, for sharing your thoughts. I would quickly pass on to the civil society reps we have in our panel to ask. So are there any threats to civil liberty that we see that are posed by this bill, either by way of intention, interpretation, or application? I'm sure there would be many people in the participant or in attendance today who would want to know what some of these threats are, and if there are any, what they could be. I would begin with Moji at this time. Just wrap up 1-2 minutes. Tell us, what threats do you see?
Okay. Whether proactively or reactively, we shouldn't be discussing about the social media bill. Now, why do I say this? Now, if you look at the law from the first letter to the last letter, you can see that the target of that law is to criminalize false statements, or in quotes, false facts. Now, when you're talking about false statements, false facts, as that law, as you will notice that even the naming of the law says the falsehood manipulations bill. Now, false statements itself are what? They are facts that cause injury or damage to the character of the person it is about. Now, the intention may be looked upon like, oh, this is a genuine thing, but it is not strange to our laws. Now, why do I say this? Section 24 of the Cyber Crimes Act 2015, as of today, is criminalizing false statements, false news, false information, because that false statement is a body. It's the heading of that encompasses the false information, misinformation, disinformation. And when you look at the way the Section 24 is couched, everything you want to think about under the falsehood and manipulations bill, that bill is irrelevant. It's just a duplicity. Now, apart from the Cyber Crimes Act, we have the Criminal Code, we have the Penal Code. All of these laws have, in one way or the other, addressed false statements or falsehood. Now, I think the confusion on the part of the government is that they think that because there's a right offline, you need to now make another new law to now define the rights online. Because as of today, every right that is available offline is available online. And every law that has existed in Nigeria that applies to every right that we have offline is applicable to the right online. It's just that the government is myopic because of its intention. That is how I look at it. Because as of today, if you look at the Section 24 of the Cyber Crimes Act, it is not used against somebody like Lai Mohammed, the Minister of Information, who has come on air and given us false information at different times, or the Nigerian army, who had given us false information during the NSAS protest. This Cyber Crimes Act is used against journalists, human rights activists like myself, is used against citizens who want to express themselves of frustration against the government. Now, I must say this. Everything about the social media bill, which of course Section 3 of that bill itself, it's majorly of concern, because one, not only does it criminalize false statements, which, by the way, I should state at this point that international community has stated carefully and have given a lot of deep thoughts and analyses and research, and came up with how will I put it, an agreement that when it involves false statements, it is just a civil wrong. It is not a criminal wrong. So in the sense of criminal defamation, it should even be deleted from our laws. For instance, in the Federation of African Journalists and the Gambia case, which I was one of the counsel in that case, the judges and the justices of the ECOWAS court came out clearly and said, if criminal defamation should not even be in our laws anymore. It is archaic. When you have if you have a law, or if you have someone who has breached your reputational rights, or they have injured your feelings or your emotions, the right place to go is to go to the civil court and take it up against them. Now, when you're having a law that is stating that people should pay 20 million or go to prison for more than 3 years for a false statement, it means that the law and the punishment is not proportional. And basically, when you talk of false statement, you're talking about the freedom of expression, which is guaranteed under the Constitution of the Federal Republic of Nigeria. Now, to abrogate that particular right, you need to ensure that whatever measures you are taking in addressing false statement, for instance, or in taking away your freedom of expression, that law must be legitimate. It must be necessary in a democratic society. And then the most important one, that every measures that will be taken to take away that right must be proportionate. And then you must know that these three tests, they follow, they're cumulative. It's not that you take one and then leave one. They must follow side by side. They must follow immediately, one after the other. You must comply with everything. But this particular law, this particular social media bill cannot meet up with that. It cannot meet up with that. And that is why, for instance, an organization actually briefed me to take that to court. And we are in court against the social media bill. We are already there. Severally, the judge had kept on adjourning the matter over and over again. But we are not, we won't end there. And even if the judgments will be against us, because you may look at it from the technical point of view that it is a bill, it is not a law. You can't go to court with the mindset of you want to enforce a right under a bill. But we'll say this categorically, that section 46 of the 1999 Constitution says any act that is likely to, that is the basis for going to the court. We have seen that there's a trend with this social media bill, and we have actually gone to court to say that there is a likelihood of the rights of Nigerians generally from being breached, and we don't want this to happen. And so it is better for the National Assembly in this circumstance to go back to the laws that are already existing and use those laws. If you want to make amends to the archaic ones, maybe the criminal codes, of course, go ahead and do that. But make sure that whatever you are doing, that whatever punishment that you're subscribing to is proportionate and it is necessary in a democratic society like Nigeria.
Thank you.
And that is why let me now make just one statement from what's his name, Justice Olatawura, and that was as far back as 1985. He says, let us not diminish from the freedom gained from our colonial masters by resorting to laws enacted by them to suit their purpose. Those in public office should not be intolerant of criticism. Whether a writer exceeds his bounds, there should be resort to the law of libel, where the plaintiff must of necessity put his character and reputation in issue. Criticism is indispensable in a free society. And that is why I would end what I have to say now.
Thank you, Moji, for pointing out that these critical issues of proportionality, and then issues of duplication, which is that most of these things we see in this law have already been provided for in existing laws that we have in the Nigerian space. Quickly, I would hear from Tosin Abolaji, briefly his thoughts on the threats, in case he has more to indicate which have not been covered by Moji already. Tosin, you have the floor. Oluwatosin, are you here? Okay. Okay, so I would quickly move over to our academic representative, or the representative from the academic community in the person of Ridwan. So are there any prospects or challenges we see from this proposed bill for the rule of law, civic processes, and cultural, socio-cultural effects of digital development in Nigeria? What prospects or challenges do we see that this bill holds, you know, in the course of practicing the rule of law, or in the course of engaging in civic processes, or participating in this, or benefiting in the socio-cultural utilities of digital development in Nigeria? Ridwan, would you please share your thoughts on this?
All right, thank you very much, Emmanuel. And I would like to just continue from where Mr. Ajijola, a point he made about making laws that actually data-driven. So putting that in context and looking at what we have right now, what we're trying to do. Of course, when you make statements, when you do things, when you share whatever it is that you're sharing online, it comes with it also responsibility. And that's something that is well acknowledged even under international human rights norms. But then moving beyond that, there are also procedures to also making some of this, making these laws. So one thing you want to have at the back of your mind is when there's a violation, what kind of remedy do people have? And I'm going to ask that if you look at the entire stretch of the social media, if the law itself, that bill itself, or if it becomes a law, it's violated, what kind of remedial procedure do you have for people who are victims of abuse under that particular law? But moving on from that, what safeguards should the law have in place? Because it's easy for us to say, oh, we're transforming into the digital economy, we're transforming into a digital society, implementing a lot of digital solutions, building digital identity, and embedding all of these things, all of these solutions on each other. But the truth is, if we continue to make all these not so respecting laws, if we continue to make all these laws that could actually endanger, not just endanger, could actually stifle the civic spaces, it also doesn't make us so fascinating an investment spot. And that's the economic bits. If you look at the power where, I mean, it's fine. We'll talk about maybe libel, the existing framework if you want to do that. But there's also something very important the bill is trying to do, which is around intermediary liability and regulations of intermediaries. But again, which is something that is actually lacking, except you look into some of the regulations as moved by the Nigerian Communication Commission, which is actually sector restrictive. But moving on from that is the fact that even if you're trying to regulate intermediaries, the Manila document there gives us some brilliant line of principles around trying to regulate intermediaries. We're trying to regulate intermediaries in a way where they actually don't even, I mean, we're not even having an independent authority to actually even play a role. We're not advancing the role of the courts in making these decisions. We're leaving it to a government agency which lacks independence to make these decisions. So these are like real life issues. And you know, there's a thing they say about dictators just don't wake up and become dictators. It is laws like this that enable them. It is people who keep quiet like this that enable them. It is when we allow things like this to go unchallenged that enables dictators to, and you know, the thing is, you can keep quiet and acquiesce to a particular law, but the truth is, that same law that you think you're making with a noble intention, if it gets into someone who has not so noble intention, it becomes a tool of repression. So these are like fundamental issues. These are like things that have really impact on people. I talked about the fact that the biggest impact I see from here is the impact it has on freedom of expression. And freedom of expression, it's not just you expressing your opinion. It's you sharing opinion. It's you even being able to access information. If social media is controlled in such a way that the only views you can see is just pro-government views, you're denied of what's on the other side. You can't even share your own view of what things should carry be. I mean, in your own reality. And I'm not speaking about conspiracy theory. I'm speaking of what is your own reality. If your own reality, you can't share it because the government don't like your views, it's problematic. And when you keep people quiet, when you suppress people from speaking, it's you're literally just growing something that is bigger than what you're trying to literally just address remotely. So there are real life issues. And for me, in addressing all of this, we need not just independent institutions to play more active role. We need to also have a right respecting law designed around how to regulate intermediaries. So, I mean, we can as well say intermediaries do have responsibilities about contents that are being shared. But we should understand that these contents, even though they are user-generated content, they have also responsibility in making sure that contents that also fit into their own community rules, and which first we mean designing community rules that are reflective of what's actually happening, not community rules designed to actually suppress people from actually expressing their views. are you able to take down that post very quickly before it becomes something that can actually result into people killing themselves? So intermediaries do have a responsibility, and there's valid reasons why we should actually look at holding intermediaries responsible. We need to hold them responsible. But in holding intermediaries responsible, we can't actually still suppress people who want to genuinely express legitimate views online. So again, we need data-driven regulations. We need data-driven measures, which should typically involve all stakeholders. Ajijola made a valid concern about when laws are being made, there is more interaction with the legal side as against engaging the technical team, academic, and I mean all of these people who are actually stakeholders in making a So all of these things should reflect everyone's input. All of these things should genuinely reflect everyone's concerns. And when we make laws that are not just data-driven, but also involve more stakeholders, diversified stakeholders, we tend to might actually reflect genuinely what would not just made up with the demand of the people, but also things that actually fit into the context of the problem you're trying to address. Because when a law is made, it means there's a problem that you're trying to fix. So when the lawmaking process itself reflects genuinely what are the concerns of the people, then of course you might be a step close to actually genuinely regulating that problem. But again, this is an ongoing conversation we should keep having. Thank you for doing this. Thank you for designing this toolkit. And of course, we need to continue to engage with the governments, provide the support that we need to provide to them in terms of making them see why we can't go this direction in trying to regulate things like this. Thank you very much.
Yeah, thank you, Ridwan, for sharing these deep thoughts. It's quite a lot. Because we are pressed for time, we'll quickly pick Mr. Verengai. Now, we know that ISOC is the global evangelist for multi-stakeholderism in the context of internet governance, internet regulation. So how do you think that, can you share quickly with us, the multi-stakeholder model, how applicable is it going to be in the context of this bill? Why or why not? In the next 30 seconds or less, just give us some thoughts.
Yes, certainly. I think history has shown that the best way to govern the internet is to use the multi-stakeholder approach. The reasons are quite simple. There are more and multiple players with very varied interests in the internet, especially in Nigeria. The government is concerned with security. That's why they are probably looking at these options. The public is interested in freedom of expression and democracy. Social media companies are interested in more users. Telcos are interested in more traffic. So it won't be very feasible to look at a problem or a challenge from a single lens. You need to be very open-minded. You need to be looking at all the important stakeholders, and otherwise you might end up in, having unintended consequences of a particular decision. So definitely, I think a multi-stakeholder approach could be a way to solve some of these issues, because the angles are multiple, and the interests are also quite varied.
Yeah, thank you. Thank you, Verengai. Now, the fact that we cannot trust any particular stakeholder to deliver effectively on the interests of every stakeholder is the argument for multi-stakeholderism. But then beyond this, especially to the panelists who are in the Nigerian space and who are familiar with the Nigerian regulatory processes, I would like to ask, so in pursuing a pragmatic multi-stakeholder approach to addressing some of these issues we have raised, Ridwan has raised the point about having an independent agency and also having some of the other factors. Moji mentioned about us having the other regulations, or allowing other regulations to do the work that they are supposed to do and avoid duplicating redundantly across board. And also Mr. Ajijola has also thrown in the technical perspective of the fact that laws should be proactive and not reactive, because when we come from a point of reaction, we have already failed in the mandate. So in pursuing a pragmatic multi-stakeholder approach to delivery on fixing some of these loopholes and insufficiencies, what are some of the greatest challenges you see, especially for these panelists who are in the Nigerian space and are familiar with the way the legal operations and legislation to the legislative process runs in Nigeria? What are the challenges you foresee? Can you share with us 30 seconds or less? Let's wrap up with that, and quickly share some thoughts from the chat. Okay, I would start with Ridwan. Ridwan, please.
All right. Thank you very much. I just want to make a light joke here. Aside the fact that Ajijola have made the point where we need to talk to each other more. That piece of law actually was copied from another country's law, and it was copied not so brilliantly, but very poorly. But beyond that, we need to talk to each other more. You can't just have lawyers looking through issues through the legal lens. It doesn't show to be the most efficient way to do things. And also, you can just have the technical folks just trying to do things. It's very important. Look at the bill itself. Look at things around content blocking and all of that. Are those things technically possible? Can we even afford them? Are you trying to balkanize the internet? And that's, if you add it to it, and also some policies that are actually quite restrictive of things we call, those things that would happen in the digital trade already, digital trade ecosystem already. So for me, I think we need to go beyond just agenda-driven lawmaking process to start having, like I said, evidence-based legislative processes where we literally put everyone together, sit down in a room and design policies that genuinely reflects the need, that genuinely looks to actually address the problems that we're trying to fix. So for me, I think we need to have some sort of, not just realization, but some sort of reorientation and looking at things from a different prism. So we need to continue to engage lawmakers. Hopefully they continue to listen to us. And of course, we continue to bring in all these insights that could also help and advance not just human rights, but also every other sphere of the ecosystem that will be affected by policies like this.
Thank you. Thank you, Ridwan. I yield the floor to Mr. Ajijola to share some final thoughts.
Okay, thank you very much. First of all, I'd like to build on what Ridwan had mentioned at the beginning, earlier on, which was that there is definitely a need for some kind of intervention between blocking and government requests, either a judge or some kind of ombudsman. Also, I would concur that there is need for a much more robust multi-stakeholder process, because really at the end of the day, what this is about and what democracy is hinged on is the issue of checks and balances. And this, I think, is the greatest single flaw in the current draft. And also back to what one of the other speakers said, you see, you have to be careful in the sense that while you have freedom to express yourself, you do not really, or you should not have the freedom to shout fire or bomb in a crowded theater. And then in terms of the most important threat that I see on the horizon, and why we need a little more control of social media, is the capacity of bad actors in social media to hack the electorate, not to hack the electoral technical system, but to hack the minds of the electorate. And what we are finding is that social media is exacerbating social political divides. Indeed, all religions abhor rumors and false accusation, but that doesn't mean because you've actually made a false accusation or spread a rumor that you should be subject to death penalty. But the truth of the matter is that if we don't rein in the excesses, then we're going to lose a lot of trust. And this also impacts things like society development, investor confidence in our nation, and so on and so forth. So hacking of the electorate, negatively influencing the electorate in the run-up to elections, especially as we see the 2023 election on the horizon, is of great concern to me. And I think it should be of concern to many of us. Thank you.
Thank you, Mr. Ajijola, for sharing these very insightful thoughts. I would yield the floor to Moji briefly. Just give us your final thoughts as we wrap up.
Okay. I think I've noted that most times when we are making laws, we take the last steps first before we go to the first step. Now, I think before you start thinking about having a law or any bill of such a magnitude like the social media bill, in quotes, one thing that the government should have started with is having this multi-stakeholder discussions. They needed to have had discussions with civil society, faith-based organizations, and then talk to the people. Now, I don't know if the National Orientation Agency still functions, but before you start talking about reining in, these, let's say, in quote, volatile expressions, you should, of course, have a lot of your populace enlightened enough to know that what your intentions are genuine. Now, there's another problem when you try to also tell your populace that your intentions are genuine and you are acting contrary to what you are postulating or what you're saying. And then, of course, the body language will also tell you whether your government is sincere enough to actually want to have discussions that would benefit the entire country, not a few sets of people. Now, if I can almost see that if a law like this is passed, that it will still be the same set of people that would be criminalized. It won't be the set of people that are in government or the set of people that have there was one word that was going around at some time, I can't remember, that you have paid your dues or you are friendly with the ruling party. It won't affect them. It won't go to them. It won't affect anybody linked to them. It will affect people, ordinary people on the street. Some guy who sells Bolly in a particular corner of the street who just has who was opportune to have this 100 naira data, and then he just saw a post and say, hey, really, is that mean? And then he shares it very innocently. And then those are the people that will be affected. So those are the people that the government should first go to, reach them, let them understand the implications of sharing information that is false or sharing information that is wrong. And then we should realize that at this time in history, we cannot be criminalizing defamation or false statement. If you have anything against a person or a sharer, now fish out the person. When you fish out the person, that is where the intermediaries are very important. Fish out the person and then take the person to the court. And that is why, of course, we need that checks and balances. You don't say that the law enforcement, they have a discretion, this wide discretion, and that if they don't, until they don't approve a particular appeal, you cannot go to the high court. There's so many things wrong, in that particular law, and it's distressing enough. We have emphasized on that. And so what we should be looking at is if government wants to do anything to regulate the way the society expresses their opinions, it's going to be difficult if the people do not understand and cannot say that the government is genuinely working for their interests. And as Nigeria is today, can we really say that the government is working for the interests of the people?
Thank you, Mojirayo, for sharing these thoughts. So we are winding down. Final thoughts from Mr. Tosin. Ajijola, he's been having some network issues. I don't know if he can hear us at this time. Tosin, can you hear us? Okay. I think the network issues are still persistent. So we've been having some great discussion going on in the chat, and our colleague Priscilla has been moderating the discussions at that point. Although I can see that much of the questions and comments that have been raised have already been engaged on, have already been touched on by the panelists. But I will just yield the floor to her to clean up on whatever is left, so that we can have a complete perspective to our discussion today, and then we will call it an event. Priscilla, you have the floor now.
Okay, good day, everybody. Just because we are pressed for time, I'll just take the questions straight up. I'll take just 2 questions because we are pressed for time. The first question I'll be taking is from Michael Alabi. He actually has 3 questions. The first one is, what is the plan to cushion the damage effect implementing this bill will have on tens of thousands of entrepreneurs whose business and services thrive around the social media sphere? Second, going by one of AHA's points, what modalities are set in place to avoid an abuse of this bill? As we all know that abuse of anything is no stranger to the government. The third question is, what does government stand to lose if there were no regulations to the use of social media amongst her citizens? I'll also take a question from Mr. Henry Chukwudi John, who said Nigeria as a country is still struggling with the full compliance of the Nigeria's Freedom of Information Act passed into law on May 28, 2011, and we are deliberating on social media bill. My question is that, won't this bill override and negatively impact the past FOI acts? That'll be all for now. Thank you.
Okay. Thank you, Priscilla. I would pass questions 2 and 4, the question 2 and 4 to Mr. Ajijola, because they relate to the focus of what he has talked about in, with regards to having some level of preparedness towards the enactment of laws like this. Then I would pass question 1 and question 1 to Ridwan, and then question 3 to Moji, because they relate to the civil society discussions. So, Mr. Ajijola, would you need us to have the questions again? Question
especially 2.
Yeah, question 2 and 4. So, Priscilla, would you read question 2 again?
Right. Okay. Question 2. Going by one of AH's points, what modalities are set in place to avoid an abuse of this bill? Wow. Is that the question?
Yes.
Or should I start from the first one? What is the plan to cushion the damage effect implementing this bill will have on tens of thousands of entrepreneurs whose business and services thrive around the social media sphere?
That's question 1. That goes to Ridwan. So question 2 and
what
question
modalities
4
are set in place to avoid an abuse of this bill?
Yes, that's question 2.
Well, okay, I think so very, very bluntly, both question 2 and 4 make presume that the bill actually is passed, and I think we should just emphasize that the bill as it is now has not passed and is not likely to pass, and that's why at this point in time it's not really about government; it's about the legislature. But having said that, what we have to do is that we have been forewarned. So forewarned means we are going to be forearmed. And thereby we must understand that there are forces in this country, in Nigeria, and I'm sure across Africa, that see such kind of bills as okay. And so we have to, in advance, being forewarned, make sure that we intensify our advocacy, not just to the National Assembly, but to government in general. That there are many, many people in the executive who fundamentally disagree with this bill. They're not necessarily the highest level of politicians, but certainly there are a good number of people. And it was clear when this bill was stepped down that even in the legislature, there are people who have fundamental questions and concerns about this bill. So that now goes to the question number 4, modalities to avoid abuse. The issue is that the bill, as of now, does not exist. And therefore, what we have to do is to make sure that preemptively we advocate and clarify and possibly even begin the process of drafting something alternate. Thank you.
Thank you, Mr. Ajijola, for emphasizing the point about advocacy and engagement across all parties, amongst all parties, rather, across board. I would yield to Ridwan to address question 1.
Yeah, sorry. Can you please, Veronica, help with the question again?
Yes.
Question 1, what is the plan to cushion the damage effect implementing this bill will have on tens of thousands of entrepreneurs whose business and services thrive around the social media sphere?
Okay. Again, like Mr. Ajijola said, the bill is actually not a law yet. It's still pretty much just a bill. So, but then if presumably it goes through the entire cycle and becomes a law, presumably, one of the things we would really like to see is to make the bill right retrospectively. If there's some sort of independent measure, then I shouldn't be focused on around regulating things that have already been legislated for. If you want to regulate the role of intermediaries, do so properly by looking at instruments like the Manila Declaration that talks about that sets out the principles for regulating intermediaries. But if you want to regulate something that is already been regulated, it's already been provided for under the law, I really don't see a point where we need to reinvent the wheel or duplicate efforts. So moving beyond that, if you're trying to, some suggestions that I would give in what the right respecting law should have is there needs to be a role for some independent institution. Liability, intermediaries can only be held to liability to the extent that they are contributing to, not, something that they are like, they are not really technically endorsing themselves. So, but beyond that, there are also valid issues around user responsibility too. Users also need to understand that what they do carries some sort of responsibility as well. So these are some of the things I really love to see. I really love to see more safeguards in the law that sort of ensure that everyone goes through not just fair hearing process, but also that it's also respecting of the rule of law and international human rights.
Thank you, Ridwan. Thank you. Moji, you would take question 3 at this time. Priscilla, would you read question 3 again?
Okay. Question 3. What does government stand to lose if there were no regulations to the use of social media amongst her citizens?
Okay.
Okay. I want to agree with Ridwan and Mr. Ajijola that, of course, every user has a responsibility that they need to discharge to fellow users over the social media. For instance, we know that even as we have this right to freedom of expression, you shouldn't express anything that would infringe on the rights of the next person. In you enjoying your rights, you must also be cautious that you do not infringe on another person's rights. And that's why we have some kind of abrogations in the Constitution that says that in the interest of national security, in the interest of public interest, public safety, public health. But yet, I need to state that at a Nigerian Bar Association conference, the president of the country comes out and states to the general, that's the body of lawyers, we have senior advocates sitting there, judges and magistrates, and says that the rule of law will be sacrificed for national security. And that was the first shock to my understanding of what the rule of law is. Now, in ensuring that the national security is protected, public safety is protected, and public health is protected, there is a very important key. That is, the rule of law must be followed to the latter. There must be due process of law. Now, for instance, this social media bill or any law, what would the government lose? Now, the government may claim that, oh, it's not safe for our national security, but I can say, in my own opinion, that if the government is really genuine about what issues have been raised or what intentions they need to protect, it is not about going out to criminalize falsehood or false statements. It is not about that. It is about ensuring that there is a due process of law. There is a due process. You should give the judiciary their due responsibility to wade into situations where they can now tell where they can now say, oh, this person, have you breached the national security in this instance? Now, and then let's always remember that whenever there's issue of national insecurity, there's always that issue of the Terrorism Act being displayed. And then, of course, in the Terrorism Act, the state security will just pick you up, and then they have this ex parte order from the court that allows them to detain you for 90 days. Now, what has that done? it has gone against the due process of law. It has gone against the rule of law, because you're not even supposed to be in custody for over 24 hours. And now you are being kept without proper investigation, or without investigation having been completed. So you will see that the government will not be losing anything if this law is not passed. It is the people that will be losing their conscience. The people will be losing their in fact, the being, that thing that makes you feel like you are a citizen of a democratic society. You will be losing it if such a law like the social media bill is passed.
Thank you very much, Moji, for that brilliant wrap-up. You know, for those who have just been joining, and you have been a very wonderful audience, we have had a very spirited discussion, and we are wrapping up at this time. We have exceeded by more than 15-20 minutes, but we have remained at peak capacity of the participants. So I want to thank you for your patience in being here up to this time. And to wrap up what we have received from our panelists, we need to be prepared, even infrastructurally, to deal with issues like the social media regulation, like Mr. Ajijola has pointed out. And like Ridwan pointed out, we need independent ombudsmanship between orders and action, so that we do not have rogue agent or agencies or government agencies acting in a rogue manner that could endanger the interests of other citizens. Then Moji has emphasized that we do not need to duplicate needlessly at the expense of each other. Let us focus more on enforcing existing laws, keeping our eyes on the Constitution and the rights it affords us. And then we would need less newer laws. And Verengai also pointed out that multi-stakeholderism is a very useful safeguard that helps us to factor in the interests of all stakeholders. And so that is the wrap-up of our panel discussion today in very brief terms. Like we mentioned at the beginning of this event, we hope to propose a policy brief that would help to guide other stakeholders in engaging, or the internet stakeholder community in Nigeria, and engaging with the legislatures, or with the legislature, or the legislative arm of government in addressing some of the issues that have been raised in this bill. Like Mr. Ajijola pointed out, we need to begin to draft something better. We cannot just sit and fold our arms and keep complaining about what the issues are. We need to begin to take proactive steps towards addressing and fixing some of these issues. Advocacy must remain within the picture as well. But I will yield the floor to Caleb at this time to share some final thoughts around the policy brief and how you can be part of this initiative. Caleb, you have the floor.
Okay, thank you very much. But before I go on and speak about the policy brief, I'd like to just recognize the presence of one very big fish that we have in the house at this point in time. Not every day that you get someone like that to be in your midst without just extracting some reactions from them. So I'd like to recognize Mr. Oluwatosin, who happens to be the past president of ATCON, and is currently the national coordinator of affordable internet A4AI. And I'd like to recognize his presence and perhaps get some of his reaction in 1 minute, because we are running against time. Thank you.
Good afternoon to you all. Thank you for that recognition. And I see my brother there, my chair, Ajijola. Great contribution to all the panelists. I totally agree. But one of the things that I like to always put in there is that the issue around the dark side of the internet is creeping into the social media. That's my view. It is going to be very difficult to guard against some of the utterances of what some people feel is acceptable behavior. So I like to see the lawyers try and solve that one. But anyway, as A4AI, we really seek continued collaboration with the Internet Society. I think the Internet Society is doing some great work. We, as ourselves, are trying to move against certain bills, like the Communications Services Tax of 9%, from not seeing the day of light. And this social media bill should also be quelled, because I've heard from reliable lawyers today that it duplicates already existing laws. So it's one thing to try and discuss this bill, But as my wise brother has said, Ajijola, he said it's not currently a law and it's not an act, but to be prepared is to be forewarned, and we should fight this together. So A4AI aligns with what Internet Society is about to achieve, and we look forward to further collaboration. Thank you very much.
Thank you very much.
And welcome, yeah.
Thank you.
Yeah, so just to give some final thoughts on what I feel about the social media bill and some of the actionable outcomes that we will be working on in collaboration with their government, which is chaired by Emmanuel. One of the few things we'll be working on is to see that we have advocacy on all levels, not just on the social media, using the social media to fight social media, which is one part of it, but to also see that we come up with policy briefs, white papers, infographics, things to help the everyday man on the street to understand the dangers of the social media bill should it pass. And some of the things we are also going to be working on with the state government is to see that we have lots of advocacy, and we do at this point seek collaborations from every person that is interested in working on this project to furthering what Emmanuel and his team has also worked on alongside the Internet Society. Also, on the other hand, we will also want to use this opportunity to encourage those who are here to perhaps inform them that there are working groups that ISOC actually has that tend to discuss some of these issues and conversations. And one thing gladdens my heart is that Abdul-Hakeem is also one of the important voices that we see that contributes engagingly with members on the Telegram groups that we have. So perhaps, Priscilla, before we end this meeting, it would be nice if you could post the Telegram group where we can continue active engagement on some of these conversations. And I'm also sure that Emmanuel has a Telegram group for the government folks that he's working with, and perhaps he's going to also share that. So we'd like to see more activity, less talk, but more activity, advocacy on every part. Go to every man on the street, let them know the implication of what is happening should this bill be passed and the dangers it has to the internet as a whole. So on that note, I'd like to close out my thoughts and my engagement with this webinar. And after Emmanuel is done, I think the Vice President will give his vote of thanks from there. Thank you.
Thank you, everyone. And thank you, Caleb, for sharing the final thoughts on the policy brief. On screen, you have all links to stay engaged with the work of the Dear Governments organization and the work of Internet Society Nigeria in this space and in this realm. We hope that you would stay engaged as we continue to drive advocacy efforts. One point that has been underscored at the webinar today is that advocacy cannot be put down, because that is what will make the ordinary citizen on the road, on the streets, to understand how issues of governance affect them. And so we are committed to this work in partnership with ISOC-Nigeria and with every other willing stakeholder in the community. So we invite you to be part of our community and stay engaged in the work that we do. And at this time, I would yield the floor to the Vice President for ISOC-Nigeria, Mr. Olorundare, to give the vote of thanks, and then we will call it a day at the top of the hour. Kunle, are you here? Is Kunle here?
Okay, yes, I think I just unmuted myself now.
Okay.
Thank you very much, Mr. Moderator. All protocols duly observed. I think we have learned a lot today, and I'm happy that this is coming at a very good time. That is to say that the law has not been passed, so this is the right time to, to do the right thing. Having said that, I want to thank all our panelists who have engaged us by sharing their thoughts And I think we really enjoyed that, and it has been a wonderful session. And without mincing words, I also want to thank the DearGovment who is collaborating with us on this project, so to say. And I would like to wrap this off by thanking my president and all the ESCOs of Internet Society Nigerian chapter. And I think it will not be a good one if I don't recognize Mr. Olushola Teniola, the coordinator of A4I. We thank you for, for your presence, and we thank you for sharing your thoughts at the same time. And last but not the least, all members of Internet Society Nigerian chapter, we appreciate you, and we appreciate all those that have joined us even far away from United States, members of Internet Society Global, and all other stakeholders. Thank you very much, and we hope to keep this engagement even on our, Telegram group. And sorry, before I finally yield the floor, I would really want to say that our working groups are going to be live very soon, and we hope that all of us will be able to join the working groups actively while we implement some, noble projects. Thank you very much. I yield the floor.
Thank you, Kunle. And then we are going to close now with a group photograph, if you don't mind. If you want to keep your video on while this is happening, please feel free to do that. And if you do not, please, you can also feel free to turn off. We are going to be taking screenshots at this time, and we invite you to be part of these just for our documentation and for our